Lordship, I beg to mention item number 5, Lordship, that the conducting counsel is not well.
Item number
5. And for the respondent number 3.
This is the
That acquisition, that enhancement of market rate and the adjacent billing.
okay. Where is the land situated?
Baridwa,
Baridwa.
just opposite CRPF camp.
The award is in your favor,
Award is in my favor, but
it's too less.
only the amount is less little.
Okay. So this is an appeal against a petition under section 80.
54, old act.
On pre-made by the respondent, not objected to by Alan. Matter is adjourned. This is the after 3 weeks.
What is it?
2 weeks.
I think this is not well. 1 and 6 also same, I think. Provident from that case, Your Lordship. Since he is unwell,
Who's unwell?
that punctually, I think, National Highway Authority Council.
Your Lordship, we got an instruction from the department. They said the meeting yet to be fixed for the
In fact, Your Lordship, as per Your Lordship's earlier order, that Provident Fund case, Your Lordship, remember, we want to sort it out. We have written letter to them to have a date for meeting, but no response came to us.
Or with the
Provident
Provident
Fund,
funds?
where we have deposited money just with regard to penalty to negotiate that part.
Okay. Or that will be a penalty part.
So, but we have written to them the letter, they have not responded us.
we need we got an instruction from the department. He said we need some more time for the meeting to be fixed.
Okay.
At least more than a month's time, I think, because we have written long back, they have not
You should
responded.
do it. If you are if you are keen to do it, do it.
Yes.
If not, then the matter has to be heard, because see, the first matter is already a very old pending matter.
Yes.
Prayer submission has been made by the parties that there is a effort to discuss the issue with the department for a settlement in this matter. However, in spite of the communication sent to the respondent EPF by the petitioner, no response has been received so far. The learned counsel appearing for the respondent EPF has, however, submitted that the department has sought for some time to look into the to come to any settlement or agreement with the petitioner herein. On prayer made, matters adjourned. List the same after 2 weeks. 2 weeks.
Three, Your Lordship.
A month's time will be better, because already so many days has gone. We have given the letter.
This is a matter after 4 weeks.
4 weeks, I think that
It is
will
made
sort
clear
us.
that if there is no settlement made between the parties, matter will be finally heard.
As you wish.
Okay.
Obliged, deeply obliged. 1 and 6.
Please, Your Lordship. Lordship, I beg to make a mention of item number 7 on behalf of Mr. H. Karwanlang. I pray if the matter can come after 2 weeks, my lord, because he is not keeping well.
What chance may be given, Your Lordship, since we have filed this since the year 2023, May 2023.
What is this matter about?
This is a 482 matter, Your
For
Lordship.
quashing of the
POXO cases.
Oh, POXO, okay.
My cases is that no offence made under the POXO, since the petitioner number 2 is a major, Your Lordship, at the time of incident.
Even if no case is made out under the POXO Act, it can still be converted.
Yes, Your
It
Lordship.
can go, under 376 or any other.
No.
So that would be on the.
This case is not a case of rape or something, sexual assault, Your Lordship. They were in a love relationship.
Lordship, that issue is still pending, Lordship, in the Supreme Court. The
No,
compromise.
that is a different thing.
Yes,
Yes, Your
Lordship.
Lordship.
That is a different thing. As far as the matter is concerned, his trial is proceeding.
Lordship.
Yes, Your Lordship.
So if in evidence it is found out that there's a love relationship or whatever, the only thing is that the court will have to take a call on that.
Yes, Your Lordship.
But as far as the trial being being done away with at this point of time, I don't think there's any anything that this court can do, or any other court for that matter.
Lordship.
But anyway, we'll look into the issue. So how many? 2 weeks?
2 weeks, my lord.
Mr. Jain Leonard G, appearing for the respondent, has submitted that some accommodation may be allowed in this matter, as the conducting counsel, Mr. A.H. Karwanlang, additional senior J, is indisposed on grounds of personal difficulties. The prayer has not been objected to by the petitioner. However, it is submitted that the matter may be heard expeditiously. Accordingly, matter is adjourned. List is still after 2 weeks.
Deeply obliged.
Highly obliged.
Lordship, I beg to mention item number 3, Lordship.
Then I have nothing else to do.
Lordship, this is regarding the termination of the service of the petitioner. Lordship. I'm praying for 2 weeks' time, Lordship.
My lord, this is a matter where we have terminated the service of the petitioner and due process of law has been followed.
Anyway, today they have.
Am I audible, my lord?
Yes, you are audible. I can hear you.
My lord.
The only thing is,
So, my lord, this
see,
is about.
now, see, prayer has been made seeking adjournment on grounds of personal difficulty. What can we do?
Oh, my lord. Then I have nothing to say, my lord.
Learned counsel for the petitioners, Miss Learned counsel for the petitioners sought for adjournment on the ground that the learned conducting counsel, Mr. P.T. Sama, is indisposed. On premium, the same not being objected to by the respondent, adjournment is granted. This is matter after 2 weeks.
Obliged, Lord.
From supplementary cost list, item number 1.
Please, my lords. This is an application under 438 of the CRPC for grant of pre-arrest bail. What has happened in this matter, my lords, I'll just give a brief backdrop before I come to the merits. Well, there was an agreement entered into between the complainant, which is the Meghalaya Energy Corporation Limited, and a certain company called Feedback, my lords, which is based in Orissa. The petitioner before your lordships is, my lords, an employee of that particular company. He's not a director of the company, my lords. He's an employee. He's the chief executive officer of that company, or was at that point of time. My lords, under that arrangement, 3 areas in Meghalaya were given out by the corporation to this company, my lords, for the purposes of raising bills, etc., on behalf of MECL and making payments, collecting payments, and etc. Now, my lords, in the regular course of business, there seems to have been some dispute between the complainant and the respondent company. An FIR came to be filed. And I'll take your lordship straight to the FIR. Page 105, my lords would find the FIR. I'm sorry, my lords, page 45. It is dated the 26th of May 2023, my lords. The relevant portion is at page 48. My lords have page 48.
Yes.
With reference to the subject cited above, I am to inform you that Meghalaya Power Distribution Corporation Limited, having its registered office at so-and-so, have entered into a distribution franchisee agreement with Feedback Energy Distribution Company, having its registered office at so-and-so, Bhubaneswar, Odisha, on 18/3/2019. In this connection, 3 areas, that is Mausanram, Fulbari and Nongal Bibra, have been handed over to the said company for operation and maintenance, collection of bills, etc. However, on many occasions, there has been considerable delay in making payment to the corporation, which in turn has led to accumulation of huge amount, amounting to Rs 15 crores. Despite several requests, the said company has not made the payment to the corporation till date. This in turn has led to severe consequences which are harmful to the corporation and the overall business, leading to monetary and other severe losses. The act on the part of Messrs. Fedco in withholding the money of the corporation is a criminal breach of trust and fraud, which are liable for legal action as per law. Hence, you are requested to initiate necessary action against the said company under relevant provisions of law. So, the limited grievance here, my lords, from the FIR as is clear, is that there is some money due. Money has not been paid by the company. They say it's an act of criminal breach of trust and fraud. I cannot go into the merits of this FIR at this stage. My application before your lordships on just on 2 grounds. A, I am only an employee of Fedco. It's an admitted fact, my lords, that I am not one of the directors or the office bearers of the company at this point of time. Number 2, my lords, post this FIR, at least an amount of 28 or 29 crores in monetary transaction between both the parties has already happened. And, my lords, this particular agreement which was entered into between Fedco and MECL.
What is the amount involved?
Here they say 15 crores is due. 15 crores.
But now you say 28 crores.
After that, 28 crores has been paid by Fedco to MECL. Agreement is still subsisting.
Okay.
Why it is relevant, my lords, I'll take your lordships to the agreement. If your lordships kindly have a look. The next page, page 49 is the agreement, annexure 2.
Yes.
Give me the arbitration clause. If your lordships kindly have a look at page 89. This is a very detailed agreement, my lords. Page 89, clause 17.2, my lords. It starts with amicable settlement. If my lords have it.
17.2.
My lords. At page 88, down below, my lords, your lordships will see amicable settlement.
Yes.
So it says, my lords, either party shall be entitled to raise any dispute or difference of whatever nature arising out of or in connection with this agreement, including its existence or validity, by giving a written notice to the other party which will contain the details of the dispute, the grounds of such a dispute, and all documentary evidence in support of the claim. The other party shall, within 30 days of receipt of the dispute notice issued under section so-and-so, furnish, my lords, so-and-so, so-and-so. I'll just skip all that. If your lordships kindly come to 17.2.5.
Yes.
Any dispute arising out of, in connection with, or in respect of this agreement, the subject matter hereof, the performance or non-performance of any obligation hereunder, which cannot be resolved by negotiation between the parties and the dispute resolution procedure as stated in the foregoing articles, shall be exclusively submitted to arbitration at the request of either party, upon written notice to the effect to the other party, and the proceedings shall be conducted on the subject of the provisions of the Arbitration and Conciliation Act 1996 by a panel consisting of 3 arbitrators. So if there's a dispute also, my lords, it provides the agreement, any contractual agreement would provide. You go in for arbitration. Well, if I may pause here for a second. Your lordships are aware, my lords, the scope of section 409. merely me saying that Mr. X owes me 10 rupees and that I've demanded 10 rupees from him and he's not paid that money, would that attract the provisions of section 409? That's the first question, Millets. The second question is, assuming, Millets, it is the truth and the provisions of section 409 are attracted, then also, Millets, if it is a company, then who would be the people who would be responsible, who have to be charged under the law? Would a manager sitting in Shillong or the chief executive officer of the company who's operating in Meghalaya be the target?
Who's the signatory of the...
Well, it is on behalf of the company. The agreement, if your lordships kindly come to page 102, page 49 first. Please come to page 49.
Yes.
First is MEPDCL, Millets.
Yes, but then...
Second is feedback. Feedback Energy Distribution Company Limited. A company having its registered officer so-and-so, hereinafter referred to as the distribution franchisee, which expression unless repugnant to the context or meaning thereof shall include its successors and permitted assigns. So it would have to be the board of directors.
Who's the signatory here?
Millets, here, that is why they're going after me, Millets, because here on behalf of the company, at that point of time, I had signed it. So, Millets, if an employee of the company is signing an agreement, the agreement is still subsisting, you are collecting money on the basis of this agreement, simply because at some point of time, Millets, I had signed it, so I am the target. The fact of the matter remains, Millets, this agreement is still in sustenance. And they are collecting money under this agreement. Your lordships, my signature, your lordships would find it at page 93. 93, Millets. For and on behalf of feedback. I am the chief executive officer in charge of operations of Meghalaya. I am required under my official designation to sign any document. That per se will not make me personally liable.
Oh, true.
The FIR is lodged against the company, Millets. It is not a case that Mr. X, who is the employee of Millets, a certain company, has taken away that money and run away. Had that been the case, Millets, 409 is attracted, I would be liable in my personal capacity. The allegation is the company entered into a contract with somebody. Company is not paying me the money. And therefore, Millets, an FIR is lodged against the company. That being the position, Millets, two officials from Meghalaya suddenly land up in Orissa, armed with a warrant of arrest issued by a court. And Millets, fortunately for me on that relevant day, I was not there, they came looking for me. So, Millets, I immediately approached the Honorable Orissa High Court. Since I am in Orissa, Millets, and your lordships are aware that the law as has now crystallized is that for transit bail, Millets, I have to first approach the court under whose jurisdiction I am residing. So, I'll take your lordships to the orders of the Honorable Orissa High Court. First order. Your lordships kindly have a look at page 184, Millets. 183, sorry. Annexure 18, page 183.
Yes.
The matter is taken up through hybrid mode. Learned counsel waives notice on behalf of the opposite party. Let an extra copy of the anticipatory bail application be served upon him. Issue notice to the so-and-so, requisites so-and-so. Till such time, no course of action shall be taken against the petitioner. Thereafter, Millets, the state of Meghalaya appears there. And, Millets, a detailed order is passed. And I'll take your lordships to the detailed order, Millets. Your lordships would find that from page 215.
200?
215, Millets. Well, the findings from page 218, paragraph 6.
Yes.
Having heard the learned counsels and perusal of the documents, it emerges that the allegations against the petitioners involves offences under section 409 of the IPC. However, it is crucial to acknowledge that the petitioner denies the allegation and is willing to cooperate with the investigation. Granting transit anticipatory bail would enable the petitioner to appear before the concerned court in Meghalaya, demonstrating his commitment to the legal process and ensuring his presence during further proceedings. Additionally, the petitioner's employment and residence in Bhubaneswar for the past 8 years, as established by his position as senior executive at Feedback Infra Private Limited, strongly demonstrate that he would not flee from the jurisdiction of court, and furthermore, the petitioner's compliance with any conditions imposed by this court would mitigate any concerns regarding his potential evasion of justice. Then they have referred to Priya Indoria Millets. Then, upon consideration of the facts and circumstances and submissions presented by the petitioner's counsel seeking transit anticipatory bail on perusal of the relevant documents, there is compelling circumstances for grant of transit anticipatory bail, which is accordingly allowed. As a necessary corollary, in the event of the arrest of the petitioner, the arresting officer shall release him on a bail upon furnishing a bail bond of Rs 2 lakhs with one solvent surety to the like amount to the satisfaction of the arresting officer. It is made clear that the liberty granted herein shall expire after 6 weeks. Needless to mention that the transit and anticipatory bail has been granted to facilitate the petitioner to appear in the court concerned in connection with so-and-so in accordance with law. The petitioner is directed to fully cooperate with the investigating authorities and to appear before the concerned court within the stipulated 6-week period, or to move for bail as the petitioner would find it necessary before a court of competent jurisdiction in the interest of justice. Failure to comply with this order may result in the cancellation of the transit anticipatory bail. The application is disposed of. So, the Honorable Orissa High Court granted me protection, allowing me to come before your lordships and move an anticipatory bail application. Now, two issues, The IO of the case concerned in this matter, says that he had issued a notice under section 41 to me. I'll take your lordships to that aspect of the matter. How that warrant came to be placed.
Yes.
No notice under 41 or 91 was issued to me. When I appeared, when I first moved the application before the Orissa High Court, and I was granted some interim protection, I, on my own volition, have responded back to the IO with an entire details of whatever was within my knowledge, also stating very categorically before him that I am fully willing to cooperate with their investigation because I have nothing to hide. As a matter of fact, the office of feedback is situated within the premises of MECL in Shillong. Business relations between both of them are continuing. 28 crores subsequently has been paid by the company to MEPDCL. That's my instruction. Fact of the matter remains, there is witch hunting going on. For what good reason, we do not know. But insofar as I am concerned, I am reiterating my position before your lordships that I am willing to cooperate with the investigation.
Now, if you say that there is or there was a demand of 15 crores, and subsequently you have paid.
I have not paid. Company has paid.
You are the company.
I am not the company, I could have been the company if I was the director.
When I say you, means you represent the company.
I am trying to draw a distinction here.
Anyway, that is not the point. The point is 28 crores have been paid. To satisfy that consideration.
No, it's a continuing, they're still continuing to raise the bills.
Okay.
It's like, a day-to-day affair.
I can understand.
So
the 28 is not at all connected with the 15?
No, it is part of that. 15 is part of the 28. What happens, is...
What would see?
If I may just explain here for a second. What happens is, for the month of January, let us say it is 2 crores. February, 5 crores. March, 3 crores. Subsequently, maybe in the month of April, 10 crores are paid. So that doesn't mean 10 crores is only paid for April. It would also cover these 3 months.
Understood.
So
that 15 would be relevant.
The 28 crores would...
For a certain period of that.
Including that 15 crores, if at all it was due at some point of time.
Anyway, that would be upon the respondent too.
The issue here, to my humble understanding, would be only this. Whether prosecution against a company would it entail, that an employee of the company would have to be victimized for the purpose of so, especially when there is no categorical allegation of any fraud or any siphoning off of funds in his individual capacity. If that would have been there, I have no case before your lordships. It is a contractual dispute between A and B. A says, I get money. B says, you have not paid money.
Anyway, now, the Orissa High Court had passed the order on 25th April.
Mallet.
Since that time, have you met the IO?
My lords, we have communicated with the IO. That is what I was taking back, take your lordships back.
Communicated in the sense that I have, direction, apart from the fact that you ought to appear or apply for a regular bail,
My lords.
you are also directed to cooperate with the
Investigation. I have. It is on record.
It would be incumbent upon you if to prove your bona fide.
My lords, it is. I was taking your lordships to that. I was taking your lordships to that. Just take me to that letter. If your lordships kindly have a look at page 143, my lords, Annexure 16. This is addressed to the investigating officer, my lords.
This is dated 29/2.
After my first order, my lords, I have started communicating with the IO. First order by the court issues notice. I'll give your lordships the dates. Give me the dates.
First order was?
First order, I'll just give you lordships, my lords. 5/1?
5/1/2024.
So on 29/2/2024, my lords, I, on my own volition, I say I've never got the notice, but I say, your lordships will kindly read from page 144.
Yes.
Sir, please note that the present reply cum written submissions are being submitted by me, Mr. Samarjit Mohanty, in response to the alleged issuance of notice under section 41 by your good self in reference to so-and-so, registered as so-and-so, that it is pertinent to note that till date, I did not receive any notice under section 41 pertaining to the present matter. I'm sorry, my lords?
You're reading page 144.
144, my lords. This is my letter to the IO.
Yes. Fine. Please continue.
That in the paragraph 2, my lords, it is pertinent to note that that I have till date did not receive any notice under section 41A pertaining to the present matter. That in the proceedings before the court of the learned assistant to deputy commissioner so-and-so, it was submitted by the investigating officer that notice under section 91 CRPC, which was issued to me, was returned to PS Sardar with a cross mark on the envelope. It was further submitted that the notice under section 41 was also issued to me. However, it was observed by the learned court that no service report regarding the same was filed. I confirm that I did not receive the notice under section 41 CRPC. That therefore, while the present reply cum written submissions, your good self is requested to provide me with a copy of the said notice purportedly issued under section 41A as referred to in the order dated so-and-so passed by the learned court of so-and-so, that the reply cum written submissions is presently premised on the contents of the complaint filed by the complainant, the copy of the FIR, and my knowledge of the dispute between the parties, that is Feedback Energy Distribution Company Limited and Meghalaya Power Distribution Corporation Limited. I say that I derive my knowledge from the official records of Feedback Energy Distribution Company Limited, of which I used to look after certain activities of the said company as representative of Feedback Infra, the parent company, during the relevant period. Therefore, I am filing my present reply cum written submissions without prejudice to my right to file a supplementary reply under so-and-so. At the outset, it is submitted that the present complaint filed by the complainant is malified and has been filed with the sole intention of harassing me owing to a dispute which is purely civil and commercial in nature, that the complainant prima facie fails to establish the commissions of any offence by me that would warrant the institution of the present criminal proceedings. It is relevant to mention that and point out that the dragging of FEDCO and its officers as an accused in an FIR is purely with intent to put undue pressure so that the company succumbs to it and the complainant succeeds to secure wrongful gain at the cost of FEDCO. I also wish to submit that the Honorable Supreme Court in various judgments has expressed and observed that there is a growing tendency in business circles to convert a purely civil dispute into a criminal case. There is also an impression that if a person could somehow be entangled in a criminal prosecution, there is likelihood of imminent settlement. Any effort to settle civil disputes and claim which do not involve any criminal offence by applying pressure through criminal prosecution should be deprecated and discouraged. It is submitted that the allegations levelled in the FIR, even if they are considered for the sake arguments, it will fall within the ambit of a civil dispute for which we have a codified law in place, and to provide relief, an appropriate forum is to approach civil court for the relief and so-and-so. That the brief factual matrix of the matter for better understanding and convenience of a good self is elucidated herein. I am a law-abiding citizen.
This is not necessary.
I'm sorry, my lords. Your lordships have seen. So he has given a detailed reply regarding the merits of the matter also. And, my lords, in the affidavit filed by the state of Meghalaya before the Orissa High Court, they acknowledge this fact that this reply has been filed. After that, my lords, from my end, I have said, whatever details are available with me, my lords, in my official capacity, I am giving it to you. Now, if the IO requires of me, my lords, to come before this honorable court, come before the investigating officer or before any court, my lords, a notice would have to come. I have not got any news.
Yes, Madam, tell me.
May it please your lordship. Your lordship, this is not, it is an admitted fact that the petitioner herein has signed the agreement with the MEPDCL as a representative of the company, your lordship. Now, your lordship, this gentleman, the petitioner, your lordship, was fully responsible for the entire operation in these three districts, Pulbari, Mausanram and Nangalbipra. He has collected the money from the consumers but failed to give it to the MEPDCL, which belongs rightfully to the MEPDCL, which is why, your lordship, a criminal case has come of misappropriation. It is not a civil dispute per se, your lordship. It is a criminal dispute because a fraud has been committed on the complainant and there has been misappropriation of the money. So, your lordship, at this juncture, your lordship, my humble submission is that, your lordship, the record may be called for from the IO and we can find out what are the what is the situation as of now, your lordship?
I think that would be a fair proposition, my lords. Records wouldn't be required before your lordships.
That would not be necessary. From the materials available now, the facts
whether really the money has been paid.
Facts and circumstances have already been made known to the court.
Yes.
Now, as far as the money part is concerned, as has been submitted or stated, that an amount of 28 crores have been.
That is not anywhere in record, your lordship. It's just a verbal submission.
Or not?
We do not know, your lordship.
To that extent,
Yes.
otherwise that would be also your duty to find out as to what exactly has transpired, and if the alleged 15 crores has been satisfied in due course, nothing remains. So,
and whether the agreement is still subsisting also, we are not sure. I mean, as of now, your lordship.
Agreement? Is it for?
It is subsisting, my lords.
What's the period?
Period.
This was executed in 2019, just before the COVID, your lordship. For how long it was?
No, it is there, my lords. Your lordship, just bear with me for a second. Just take instructions.
Term of agreement.
Well, it's from till 2029.
Still subsisting.
That means it is subsisting.
It is subsisting,
or maybe if it has been terminated, because there's a provision for termination
if it is subsisting,
also.
Then what remains is the whatever has transpired within this period would be based on the contents of the agreement. So, if at all there has been any misappropriation, as you call it, or they would call it otherwise, then of course that arbitration clause is there. You can always proceed in proper forum, because these are more or less civil in nature.
But in the meantime, a notice may also be issued to the complainant, your lordship, because they're also a party here.
Who is the complainant?
MEPDCL.
Or should have
R4, my lords. Your lordship would have to issue notice. I cannot serve them.
Notice has to be issued against them.
It is, my lords, it's a.
I thought you are representing.
No, my lords, it's a GR case. It's a GR case. The complainant cannot come and improve upon the case. It is initiated on the basis of an FIR. It is my duty, my lords, to come before your lordships and also bring the complaint. It is the state.
Because the investigation is your lookout.
Yes, your lordship.
You would be more privy to the the report or the information or the.
So I'll need some time.
Progress of the investigation than others.
Because the complainant will come before your lordships and my lords, and they'll give their side of the story.
Why have you made them a
But
party?
they are a party, since they are the complainants. They have been aggrieved by the act of the petitioner.
I should come with clean hands. I don't want to, my lords, steal a march upon anybody, which is why, my lords, we made them a party. Your lordships, at the time of hearing the final applications, also probably hear the complainant. In my lords, strictly, I was not required to.
They are the aggrieved party, your lordship.
This court was inclined to accede to your prayer, and even right now, but then you have complicated the issue.
No, but in so far.
Anyway, we'll call for the records.
Let the record
may be called and the notice may be issued to the complainant.
Until then, my lords, the protection on me, my lords, may be continued.
P. Chidambaram case, Sandri Chandra case. You've got a case, but then anyway, the aspect of misappropriation, that is a different thing altogether.
Well, it's because if we have to go specifically under whose, if there is a fraud, my lords, then we'll have to go back to Standard Chartered. Then they would have to lift the iron veil, my lords, and see who are responsible for the affairs of the company. An employee of the company, my lords, cannot be dragged out merely because he signed the agreement or he was the main guy in Shillong. You cannot.
He was in charge of the operations here, Your Lordship.
Even assuming that.
He may be.
Assuming that, my lords.
He may be, but he is a representative.
He is a representative of the company, yes, Your Lordship.
It's a juridical body, so you will have to go after that. So therefore, the Honorable Supreme Court lays down the test, my lords. You have to lift the iron veil, find out who are there in the affairs of the company.
Whatever the case may be,
My lords.
if he is spearheading the organization, then
the operations here.
He's not spearheading the organization, my lords. That's what I'm saying.
As far as the agreement is concerned.
During that period of time, he was here for a limited period of time.
He was managing the show
Whenever,
here.
my lords, your lordship will kindly appreciate, when a company is entering into a contract with the government, they send a senior executive. He was the senior executive who was there, signed. As a matter of fact, that contract on the other page says, my lords, who's the contact person? It's not me. I'll just quickly show this to your lordship, my lords, because when we were examining this agreement, this came by. At page 93. There are two people who are specifically deputed as contact persons.
The contact person may not necessarily be the person in charge.
But we have filed an affidavit before the Orissa High Court where it has been clearly stated that he was the person fully in charge of the operations here.
Even assuming I am in charge of the full operations of the project in Meghalaya.
Collection and distribution.
Yeah, as long as the allegation is not against me in my individual capacity. If the complainant were to make an allegation, my lords, that yes, Mr. X was in charge
Anyway,
and he has siphoned off the money.
This appears to be purely, commercial in nature. If you just, get your instructions, if you find that, if, as Mr. Paul had said, that 28 crores have been disbursed in the meantime, if it covers the 15
crores which was misappropriated.
These are all, it becomes just a mere formality. If it is otherwise, then
we'll seek instructions accordingly. In the meantime, METB, this
you take steps.
number 4
we'll take
may
steps,
also be
my lords, may
issued
kindly
notice.
continue with the interim protection that was granted to me by the Orissa High Court.
Heard Mr. K. Paul, Leonard, Senior Counsel, appearing for the petitioner, who has submitted that the petitioner, being apprehensive of an imminent arrest in connection with GR case has been registered.
Yes, my lords.
Where is the
It's there in the FIR.
Yeah, case number 140, Your Lordship.
At page 45, your lordships will kindly see GR number 263 bracketed A of 23.
Page 45.
Yeah, my lords. On top, right on top. GR case number 263 bracketed A of 2023, my lords.
Pending before the court of.
Well, it's CJM, it would be CJM, my lords. It's Sadar PS, so it will be CJM.
Pending before the court of the Leonard CGM at Shillong. So I to under section 409 APC has approached this court with this instant application under section 438 CRPC with a prayer for grant of pre-arrest bail.
This is the number. Oh, this is the Southern PS case.
GR number?
Yeah.
It is also submitted that the petitioner has approached this court pursuant to a direction by the Honorable High Court of Orissa, wherein by order dated 25/4/2024 in ABLAPL, one word, capital number 15446 of 2023 on an application for grant of transit bail. The prayer was the direction of the Honorable High Court of Orissa, while granting the prayer of the petitioner, had directed him to to move for bail before court of competent jurisdiction within 6 weeks from the date of the said order, that is 25/4/2024. Hence this petition. Hence this application. Though the learned senior counsel had briefly proceeded with the merits of this matter, however, it is prayed that before this petition is finally heard and disposed of, notice may be allowed to be issued upon the respondent number 4. The respondent number 1, 2, 3, 2 and 3, 1, 2 and 3 respectively are represented by Ms. Janet A.G. As such, no formal notice is required to be issued on such respondents. On consideration of the submission made, the petitioner is directed to take steps for issuance of notice upon the respondent 4. The same returnable within 2 weeks. In the meantime, as prayed for, interim bail is granted to the petitioner with a direction that he shall not abscond or tamper with the evidence or witnesses, and that he shall see if a matter has been if the case has been registered as GR case, it means the charge sheet has been filed.
Not yet, my lords.
They've just, only the Sadr PS case has been registered as a GR case.
But usually it would have been, it should have continued as Sadr PS case.
Ideally, yes, my lords.
Still the charge sheet is filed.
Ideally,
That
yes.
is what is done.
And then it is
Probably, my lords,
it's
because
taken
they want,
cognizance of by the regular court.
probably they wanted to go outside the jurisdiction of the Shillong courts, my lords. That is why they went before the court.
I'm not
Very, very peculiar, again, very peculiar, my lords.
Except, if it is a complaint case, of course.
It's not a complaint case, my lords, admitted.
Oh, it is not.
No, this is an FIR. The
FIR,
FIR
yes,
was
yes, yes.
lodged,
So a GR case. has
GR
been-
case.
yes, yes. Kunum to appear before the IO as and when required. This is matter accordingly. 2 weeks.
Obliged. Obliged. I'll oblige.
Daily list item number 2.
Oh, why nay? I'll October the respondent, state respondent, produce copy of the case diary on an exact fix. All the respondents are here.
Mr. Diaz.
My lord, I'm here, my lord. Due to election, my lord, my entire locality has been blocked, my lord. So I'm here, my lord.
Okay, if we are able to hear you, then we'll hear you.
My lord.
If there's no technical snack.
Sometimes it happens.
Probably not to my side, my lord, the internet is not working properly. This side it works, my lord.
Once upon a time, this court has even heard a slight remark of a lawyer.
No, my lord. I'm just pulling the leg of my friend, Mr. Pillan. His office is in Nongtumai.
I'm not from Nongtumai, so I don't mind.
The office, my lord.
Yes, Mr. Hajarka.
Yes.
What is this case about?
Regarding the Nokmaship dispute, my lord, joint Nokma and Nokma.
Again, before EM and CEM.
Yes.
Please.
May I please, your lordship? That brief fact of the case is that one late Shana Sangma and one Jimra Sangma purchased a land from late Zenang Nokma of Rongbegiri village at rupees 8,000 dated 8/1/1918, my lord. And petition was filed to the DC. Then the DC directed to erect dips pillars, boundary pillars, and pass an order on 9 January 1980, my lord. Recognize the sale, and Mojadar also dated 21st January 2018 erect, and there are erect the boundary pillar, my lord, that is called dips. And thereafter, what happened? This Karwil District Council also prepared a record in Form 27, that is called Till Phase. And since then, thereafter, this Shana Sangma and his wife, Japrai Marak from Raksham Kalen, become the Nokma dated 9 January 2018. And the Raksham Kalen has been continuing to hold the Aking, Rongbegiri Aking till date, my lord. So I am coming to the page number 21A, my lord. And type copy on page number 26, my lord.
This is?
This is the statement of Zenang, who has sold the land to Shana and Jimra, my lord.
Sale statement.
Yes. The following is the request of undersigned humble petitioner, that I have sold the following western portion of my village Rongbegiri, located in Elaka of Tanjing Loskor, to one Shana Nokma and two is Jimra Nokma of the village Rongbegiri, as per the boundary shown below, in the presence of one Harshan Marak Mojedar and Tenzing Loskor, and also in the presence of other Nokmas belonging to the continuous Aking surrounding areas, my lord. So that land was purchased from one Jenan Sangma, and that is the statement of Jenan Sangma, my lord, in the presence of surrounding Nokmas.
Yes.
Dated.
Who is this Jenang Sangma?
He is the seller, my lord, of Aking land.
Is he a party in this proceedings?
No, that is the whole this thing, my lord. We will giving the statement. Party is the respondent number 4. He is given that statement on 8 January 1918, my lord.
8 January 1984.
18, my lord. Then I come to page number 29, my lord.
Yes. 29.
Yes, my lord. He has given the statement before the DC FJ section, my lord. Jingnang Nokma present and state that he has sold the land to Shana and Jimra for rupees 800 header may erect dip as prayed for by the purchaser. So it is given the order to make the boundary of the land. That is the order of this DC, that DC of this. That is on 9 January 1980.
Yes.
Then I come to page number 31, my lord, boundary pillar. Shall I read out, my lord?
Yes.
As per your order dated 10 January 1918, number 809, on the land purchased by the Shana Nokma and Jingra Nokma of Rongbengiri village from Jinang Nokma of Rongbengiri village, 6 boundaries pillars have been erected with the map being made thereon on 21st January 1980 at the following point, my lord. These are the boundaries of the Aking land, my lord.
Yes.
Title page number 38, my lord, page number 38. That is prepared by the district council.
Title page.
Yes, my lord. 38, my lord.
Yes.
There's giving the summary of the decision taken by the DC and the boundary of that Aking land which has been purchased from late Zenan Nokma, my lord, on 8 February 1918, my lord.
Yes.
Thereafter I come to Annexure 5. Type copy is Annexures, page number 43, my lord. Order dated 15/4/1987, my lord.
Yes.
An application submitted by Jenang Sangma dated 18/3/1987 is received by me and perused. That is the existing Nokma. File an application to enter the name of his daughter and his son-in-law, my lord. The existing Nokma of Jenang Sangma and his wife Srimati Benish Marak Nokma, eligible of Rongrengiri, stated that during their lifetime they are willing to register the Nokmaship to their heiress daughter Srimati Justina Marak and her husband, the heir son-in-law Sri Aban Momin, including themselves. That is the present petitioner here. As per will of the existing Nopar, the remaining daughters and their husband and the connected Seras are also unanimously agreed to include their heiress daughter and heir son-in-law as they have submitted the written document of this office, and the other son and daughter has no objection for that, for entering the name of Aban Momin and his wife. Under the circumstance, I appoint Sri Aban Momin and his wife, Srimati Justina R. Marak, as included Nokma of Rongrengiri, along with the existing Nokmas with effect from 15 April 1987, my lord. And since then, I was the Nokma since 15 February 1987 continuously, my lord. And there is page 47, my lord, list of Nokma. My name is recorded in the last, Aban Momin and Justina Armarak.
Page 47.
Page 45, my lord, not 47. Then keep this.
Yes.
Then affidavit in opposition.
This is what? This is the list of what?
List of Nokmas, my lord, from Raksham clan. GT, my lord, that is in short called GT, my lord. Then, my lord, what happened? The district councils, on the application of the respondent, pass an impugn order on 22nd August 1997, my lord.
That is page.
That is in the affidavit in opposition. It is enclosed, my lord. In my copy, it is not there, but I have got the copy of it.
So it was not part of your pleadings.
It is part of the pleading. I have already pleaded this one, but this enclosure I could not do at the time of filing this writ petition, my lord. That against this order and coming before this honorable court, my lord. Two orders.
If I just inject, my lord.
Yes.
It is mentioned in the response number 4.
The counsel for the petitioner is relying on a document which is not before me, my lord. And he is relying on the affidavit that is filed by the private respondent. That affidavit has not been exchanged to us, my lord. It has not been supplied to us, my lord.
No, it is already exchanged. But it is there. It can be taken as a part of the.
You have not received copy of the affidavit?
Affidavit filed by the private respondent, my lord.
Who's
We've not been supplied with. That is why I was a bit taken.
I was under the presumption, Your Lordship, that they have already received a copy.
No, my lord, we have not received. Just I was checking my file. That affidavit is not there. Moreover, Mr. Hazarika is relying on the document.
When a matter
has
come up for hearing,
yes, my
it
lord.
is assumed that the pleadings are complete.
Yes, Your Lordship.
Yes.
Now you say that he has not received a copy.
I always thought like that they have received the copies, Your Lordship.
No, they have not supplied us, my lord. They have not supplied.
Then we'll give them a copy, Your Lordship.
Fine. What do you do?
Let it come up tomorrow, my lord. Let it come up tomorrow, my lord.
Nothing. After 1 week.
Let them supply us today, my lord.
On Monday, my lord. Next Monday.
Let's see.
But this was never raised. All this time we had the
But you
hearing,
should have,
Lordship.
you see, Mr. Day, it is your duty to
My
go
lord.
through your papers. You see, whether you have received.
Yes, I totally agree. Yes, I totally agree, my lord. But Mr. Hazarika is relying on
exactly
certain documents which is not enclosed.
That was in his, or rather, that is in his possession.
No, my lord, I disagree with my learned senior, where my lord he has said that it is a paper from the district council. When he has to project his case, my lord, he has to rely on those papers which he is not need to enclose, my lord, with his writ petition.
Exactly. That will be looked into.
Because now, my lord, we have rebutted all the allegation which has been brought by the petitioner in the writ petition. And now he is going to rely on certain documents which was not part of the writ petition, my lord.
No. It is. I will supply it, my lord.
It's before Your Lordship.
Now, anyway, my lord.
We'll have it, Your Lordship, after 7 days or 10 days or what?
On 10th, my lord. After that, I will be out of station on Monday, my lord. Next Monday.
When the matter.
I'm ready, my lord.
When the matter was heard, the learned counsel for the petitioner, Mr. A.H. Hazarika, has, in course of his argument, referred to the counter affidavit filed by the private respondent number
4.
However, Mr. S.D. Leonard S.C. GHADC appearing for the respondent. However, Mr. S.D. Leonard S.C. GHADC appearing for the respondent number 1 and
2 and 3.
1, 2, and 3.
1, 2 and 3.
Has submitted that he has not received copy of the affidavit of the said affidavit filed by the respondent 4. As such, the hearing could not continue today. the respondent number 4 is directed to supply the copy of the said affidavit to the respondent 1, 2, and 3. Matter hearing will resume on the next date fixed.
Meanwhile, my lord, on 10, my lord.
As prayed for, this is matter on 10.
May I please, your lordship, I may be allowed to file a small additional affidavit and closing this document.
What document?
That which is.
It's already part of the records. It's in my affidavit.
One
It's relying on my affidavit.
It may be allowed, my lord. I will file a small
How
affidavit.
can it be allowed, my lord?
No,
At
no.
this stage of the hearing.
No,
an
I am
additional
praying.
affidavit.
As Mr. Nobria said.
No, another document also required to be filed, my lord.
No, my lord, may kindly figure it out, my lord.
At this
This
stage,
writ
No, my lord,
which has been
only
filed,
for
my lord.
and only for filing this document only. In lieu of making a part of this thing,
Then
I'll
again,
file
we
it.
have to reply to that. And your
No,
lordship
no
should
need,
not be
my
allowed
lord.
at
That
this
is
stage.
That's fully permitted, my
It
lord.
is already
Unnecessary,
there, my
lordship.
lord. In the
you just
just I'll produce
you refer it.
yes,
The
I
court
just
will, the court will look into it
Yes,
and let
my
the other parties refute your
yes, my lord.
submission. And
Just I will produce that one
It's
at the
pushing
time
for
of the
hearing at the
and
same
take
time
as
also
a part
is.
of it.
in fact, it is,
But
it is incumbent upon you
Yes, my
to
lord.
file such document if you are
Yes,
relying upon
Yes,
such
yes.
document. Now, at
That
this
is,
point of time,
I
you
am
say,
admitted, my lord. I will file as it may be taken
no,
as a part of a record.
not necessarily.
Yes.
We'll see. You continue with your argument and we'll see.
Yes, my lord.
So,
Much obliged, my lord.
Monday. Obliged.
My lord.
Item
Hello,
number
miss.
4.
Your Lordship, I pray for some accommodation in this matter, Your Lordship. Can you have it after 1 week, Your Lordship?
why have you not mentioned it during the mention hour?
I was not there, Your Lordship.
The respondent wasn't there, Your Lordship, in the morning.
I was on next year.
Whatever the case may be, see, whenever a party wishes to seek adjournment, it would be proper for you to first inform the other side, not necessarily in the court premises, even over phone the previous day. Then, see, if you come before this court and say that yes, I have got consent of the other side, the court will, will agree to it. But if you come suddenly and say the other side is not here, we have to look for them, it looks very awkward.
My
That's
apologies,
number
Your
one.
Lordship.
Number 2 is you should not come when the matter is called up, because now the court is inclined to hear the matter. Anyway, on prayer made by the petitioner seeking adjournment, seeking accommodation on ground of personal difficulty, matter is adjourned. List the same after 3 weeks. Thank you.